guys, Florida Real Estate Sales Association. Florida, that's the sound of my phone falling. Happy Sunday morning. Florida Real Estate Sales Associate course, Chapter 5, the pointers, brokerage operations. This is actually one of my hardest chapters to study. It's a lot of memorization, but let's go for it. Brokerage office requirements, principal office requirements. Each active broker is required to open and maintain an office which must be registered with the DBPR, Department of Business and Professional Regulation. The office must consist of at least one enclosed room in a building of stationary construction where negotiations and the closing of real estate transactions can be conducted with privacy. A broker must maintain books, records, and files pertaining to transactions of others in the broker's office for a period of at least 5 years. Principal office registration is transferable. If a broker desires to conduct business from more than one office, each additional office must be registered individually as a branch office with the appropriate fee paid. If a broker closes a branch office, the registration of the branch office cannot be transferred. Each new branch office location must register with the DBPR, and the appropriate fee must be paid. If a branch office is closed and later reopened in the same location during the same 2-year license period, a reissue of the license may be requested without additional fee. If a branch office is moved, a new application for registration with a proper fee paid is required for the new location. A broker is required to have a sign on or about the entrance to the office and all branch offices where it can easily be observed and read by persons entering the office. It may be placed either on the exterior or interior of the office. Advertising. All real estate advertisements, including yard signs, newspaper ads, business cards, and or any other advertisements must include the registered name or trade name of the brokerage firm. A sales associate or broker associate's name may appear in the ad in addition to the registered name of the brokerage. If a licensee includes his or her personal name in the ad, the licensee's last name must appear exactly as it is registered with the commission. Blind ads. A blind ad is any real estate advertisement that does not contain the registered or trade name of the broker, or for which there is doubt that the ad is that of a real estate broker. If a licensee's personal name appears on the advertisement, the licensee must use at least his or her last name as registered with the commission. Personal transactions. Licensees must make known their status to licensees as members of the public. To members of the public. This disclosure must take place prior to entering into serious negotiation, but is not required to take place in the preliminary stages of a transaction, such as newspaper advertising. Earnest money deposits. An earnest money deposit is showing good faith on the part of the buyer, usually accompanies an offer. If no contract results, the deposit would be returned to the buyer. Should the offer become a contract, the deposit acts to protect the seller in the event of later buyer defaults. Default by the buyer usually requires a deposit to be forfeited in favor of the seller, liquidated damages, to compensate for having removed the property from the market. Post-dated checks are considered to be promissory notes and can be accepted as earnest money with the seller's approval. Escrow account. This is not the chapter that I thought was my hardest. It's a different one. It's the one with the different forms of legal business. An escrow account or trust account may be in a commercial bank, title company, having trust powers, credit union, or savings association located in the state of Florida, and not in a stock or bond brokerage house. The broker is not allowed to commingle or deposit the personal funds of any person with any funds being held in escrow, trust, or on condition. Sales associates and broker associates that receive earnest money must deliver the deposit into the broker immediately. Immediately is defined as no later than the end of the 3rd business day following receipt. A sales associate that receives a deposit on behalf of his or her employer must deliver the deposit to the employer no later than the end of the next business day following the receipt. Saturdays, Sundays, and legal holidays are not considered business days. Escrow account records. A broker who receives a deposit must keep an accurate account of each escrow deposit transaction. The broker must make available to the DBPR or authorized representative all deposit slips and bank account statements together with all agreements between parties to the transaction. Conflicting demands from the buyer and seller demanding that the broker release escrowed funds is termed an escrow dispute. If a broker receives conflicting demands for escrowed funds, or if the broker has good faith doubt as to which person is entitled to escrow property, The broker must give written notification to the Florida Real Estate Commission within 15 business days from the date of the last party's demand. I'm going to read that one more time because I wasn't paying attention. Conflicting demands from the buyer and seller demanding that the broker release escrow funds is termed an escrow dispute. If a broker receives conflicting demands for escrow funds, or if the broker has good faith doubt as to which person is entitled to escrow property, the broker must give written notification to the Florida Real Estate Commission within 15 business days from the date of the last party's demand. Court action, litigation. A suit in court can be used to resolve the escrow dispute. The broker would file a bill of interpleader if he or she did not claim any rights in the deposit under dispute. Concealment occurs when a broker fails to disclose information to a party to whom the broker has such a duty, and that is material to his or her decision. Typically, a broker must disclose any fact, report, or rumor concerning the transaction to the principal. If the broker is aware of the ignorance of the customer, however, the broker may have a duty to speak as well. Culpable negligence occurs if a broker operates in a reckless, careless, or excessively negligent manner. Culpable negligence is negligence for which one can be held legally accountable. A sales associate who forgets to collect an escrow deposit as specified in a sales contract may be charged with culpable negligence. Misrepresentation is the misstatement or omission of facts. Misrepresentation can lead to fraud if statements are intentional and relied upon. Lotteries. A broker uses lotteries or trading schemes involving selling of certificates or chances to induce any person to buy real estate is guilty of fraud. Contests where no purchase is required may be permissible. Real estate brokerage partnership. Real estate brokerage partnership must be registered with DBPR in the name of partnership. I beg your pardon. Real estate brokerage partnerships must be registered with DBPR in the name of the partnership and have at least one partner licensed as an active broker. Inactively licensed brokers and unlicensed persons can be partners but cannot perform real estate services. However, they must be registered with the DBPR. All partners who provide real estate services to the public, either directly or indirectly, must hold an active broker's license. Sales associate or broker associates cannot be partners in real estate brokerage partnership. This was actually the chapter that was hard for me, but I didn't highlight most of it, so it's not so hard. Joint venture. Joint venture or joint adventure is similar to a partnership in some respects. The participants in a joint venture have joint and several liability. However, a joint venture is a temporary business involving a single transaction or a predetermined number of transactions. Since their relationship is temporary, they cannot bind one another to any new transactions. I guess it's sort of like I guess they would be like hiring each other like a consultant in a certain way in a joint venture. The corporate, because it's just for like a limited amount, it's like a specific task. The corporate name must include the word company, incorporated, or Inc. This is a corporation for profit. No business is allowed to use the word company in its name unless it is formed legally as a corporation or unless the word not Inc. are added. Real estate brokerage corporation. A real estate brokerage corporation must provide proof of legal corporate existence prior to initial registration with the department. The corporation will be registered and the names of all offices and directors of the corporation are registered. At least one corporate officer must be licensed. Must be licensed as an active real estate broker. All corporate officers and directors who provide real estate services to the public, either directly or indirectly, must hold active real estate brokers' licenses. A sales associate or broker associate cannot be an officer or director in a real estate brokerage or corporation. Anyone can be a stockholder, licensed or not. The following businesses can register with the DBPR to perform brokerage services. Brokerage services. Sole proprietorship, corporation for profit, corporation not for profit, limited liability company, general partnership, limited liability partnership. The following businesses cannot register to broker real estate: corporation, sole, cooperative association, business trust, unincorporated association, and joint venture. And there we have it for chapter 5. Round of applause. You've done fantastically well. Till the next chapter.